patients' right advocates and is helping to lead this charge to help patients seek relief from some of their mental health issues by using psilocybin. So Catherine will start, she'll speak, and then she will introduce the doctor. And then Dr. Aggarwal, apologies, Doc, I always botch that, will introduce Erinn, who's one of the participants in the suit. And then we will take questions. Probably the best way to do your questions is put them in the chat box, and then Catherine will respond from there. We'll probably speak between 20 and 30 minutes. And then after that, we'll have time for questions and answers. And if you need any follow-up materials, just let us know and we'll make sure we can get those to you from there. So with that, Miss Catherine, it's all you.
Thanks so much, Brad. And I already see my chat box is active with the suggestion to encourage people to keep their cameras off and their mute on. So thanks for that reminder. Thanks everyone for coming to hear a little bit about this case. It is a first of its kind lawsuit. My name is Catherine Tucker. I'm special counsel at Emerge Law Group, where I co-chair the psychedelics practice group. I am a 30-year career patient rights advocate, and some of you may have covered the work that I've done around the rights of patients, particularly at the end of life in other cases. And so this is a really interesting case that we'll be talking about this morning. I'm really excited to be doing it with colleagues from Perkins Coie, which is a firm where I practiced for a number of years, and also attorneys from Yetter Coleman. And you'll see all of the counsel's names and contact information on the petition for review. All of the documents related to this case, the petition for review, and the underlying documents are available on the Emerge Law Group website on the Right to Try page. So I hope you'll take the time to pull those up and take a look at them. All of the counsel on this case are really proud to be representing Dr. Sunil Aggarwal of the Ames Institute in Seattle, which is an oncology, an integrative oncology clinic, and a number of his patients, one of whom you'll meet today, Erinn Baldeschwiler. The patient petitioners both have advanced cancer. And the case is about seeking to ensure that patients with serious life-threatening illness are able to realize the promise of state and federal right to try laws and access psilocybin for therapeutic purposes. When I turn this over for Dr. Aggarwal's comments, he'll spend a few minutes sharing with you what has been the really quite amazing research in clinical trials in recent years about the safety and efficacy of psilocybin to relieve non-physical suffering in patients with advanced illness. And these studies are coming out of the leading research institutions in the US, and they've been widely reported in the press. Many of you may have been following the studies out of Johns Hopkins, NYU, UCLA, and they're quite impressive. And they've been written about in books like Michael Pollan's How to Change Your Mind. So this topic is of interest in the wider public outside of just the medical and legal communities. The importance, to my mind, having spent 30 years in advocacy to improve end-of-life care, is that there has been a gap in the palliative care toolbox, and that is to address non-physical suffering, anxiety, and depression. And that's what this investigational drug psilocybin does. So right to try laws have swept the country in the last 6 years. From 2015 to today, 41 states and the United States government have adopted right to try laws. These laws recognize that patients with serious and advancing illness don't have the luxury of time to wait for the very long new drug approval process to wend its way through to completion. So they open access, they are intended to open access to investigational drugs that meet a couple of requirements. Those requirements include that there has been a successful completion of a phase 1 clinical trial. That is true with regard to psilocybin. The investigational drug must remain under active investigation. That is also true with psilocybin. Psilocybin, hence, is what the right to try laws designate as an eligible investigational drug. So the patient petitioners in this case are eligible patients as contemplated by right to try, in that they do have serious advanced illness. They do have anxiety and depression, which has not been relieved with conventional therapy. They are not eligible to participate in a clinical trial. There are no clinical trials enrolling in the Pacific Northwest. They are aware that this is an investigational drug and accept the risks of that. So they meet all the requirements of right to try. They have a willing clinician. And so they very much are within the ambit of right to try and should be able to access this investigational drug. I want to also put a little frame around the reality that in all 50 states, a patient with terminal illness is able to choose the intervention known as palliative sedation, which is where the patient receives controlled substances to eradicate consciousness so that awareness of suffering is eliminated, food and fluid are withheld until death arrives. That option is available in all 50 states. In many states and in a growing number of jurisdictions, patients are also empowered to choose aid in dying, sometimes called death with dignity. And that is where the patient is able to access controlled substances to advance the time of death and avoid further suffering. In these jurisdictions, one would think that surely patients with advanced illness should be able to access controlled substances to elevate and expand consciousness and very possibly impact how they feel about other choices that are available to them. And this is certainly the view of some in the palliative care community who have written and spoken and educated on that very topic. So this case is about opening access to the eligible investigational drug, psilocybin, and through that, certainly improving quality of life for these patients and very likely also extending life. As you may have reported and been following, our neighbors to the north in Canada have opened access to this very same drug, psilocybin, for this very same purpose, which is relief of anxiety and depression in terminally ill patients. And so we're very much hoping that this experience in Canada is what we can achieve here through this lawsuit. And finally, before turning it over to Dr. Aggarwal, I would say that what we hope the DEA would be doing under Right to Try is creating a user-friendly access, a user-friendly approach to how clinicians like Dr. Aggarwal can navigate the system to obtain an eligible investigational drug for an eligible patient. So that's the intention and the hope of this lawsuit. So that's my brief introduction. It's my pleasure now to turn it over to Dr. Sunil Aggarwal of the Ames Institute in Seattle.
Thank you. Good morning. I'm here today to speak on behalf of my patients, Erinn Baldeschwiler and Michal, who are patients of mine at my clinic in Seattle, Washington, where I practice integrative palliative care in conjunction with naturopathic oncology and other specialties. My patients have advanced illness. They've been given diagnoses that are considered terminal, given the statistics of of the tables that are available for their conditions. They face significant distress related to their terminal diagnosis, the stress of treatments, the uncertainty of whether they're going to be there in the future for their children and their loved ones, the ability to make meaningful decisions regarding their future, the stress of medical surveillance, and constantly are seeking out new therapies and treatments to address their well-being. In the field of palliative care, our focus is on maximizing quality of life in patients with serious and life-threatening illness, no matter their what other treatments they're receiving. The goal is to maximize quality of life at all costs. I mean, with all possible therapies. We actually know that high quality palliative care in patients with life-threatening illness can actually not only improve pain and symptoms, but can also extend survival. There was a study done, a randomized trial at Mass General Hospital a few years ago that proved this, and other studies have borne this out. And we think this has something to do with the way that quality of life, well-being, relief of depression and anxiety can improve your immune system and to help fight cancers better. It can also improve your ability to tolerate other therapies that might be needed to heal. So palliative care is a matter of life and death, in addition to a matter of quality of life. And for my patients, one of whom you'll meet today, they know that there is an eligible therapy out there that has been going through clinical trials. That is a naturally occurring psychedelic substance called psilocybin. They are aware that that substance has been used in studies and has been shown to be effective in relieving depression and anxiety symptoms in patients with advanced cancer. This is no secret. Catherine, our attorney, has mentioned it. This has been published in the leading journals coming out of the leading academic medical centers. There's 3 studies that have been done in the United States that have been published, randomized trials in patients with advanced cancer utilizing psilocybin assisted therapy. One study run by Stephen Ross at NYU, a study first author Roland Griffiths at Johns Hopkins, and Charlie Grobe at UCLA. There's also been studies done in other countries as well. But just looking at what's been done in this country, we know from those 3 clinical studies that patients with advanced cancer can have significant relief lasting, in some cases, up to more than a year and a half from doing one series of sessions with psilocybin assisted therapy. These are very profound results in patients who are dealing with a terminal and life-threatening illness. We just don't see these kind of results with other interventions that we have available in palliative care, other drug therapies. It's remarkable, and absolutely these substances could extend life and certainly quality of life in my patients. And I deemed them eligible to access this medicine under the right to try law that I practice under in Washington State and at the federal level. And I asked them to sign informed consent documents to this effect, that they consented to, acknowledging their diagnosis and their wish to pursue this treatment, which is required under the law. It was signed in front of witnesses. And then we sought to bring this to eligible manufacturers to secure this medicine under the law, which is their right, and is my right as their physician to request. We have been denied this, and the DEA, who we asked for permission to clear a path for us to do this, they also denied our request. And this is absolutely unacceptable for their care, because they have this right under the law, and the law states that medicines like this should be made available expeditiously for patients. I have followed the laws under the DEA for many years, practicing as a physician. When I first got my license, my DEA license, I adhere to the rules, and I expect the DEA to also adhere to the rules as well. And if those laws or rules are there for those patients, there should be an exemption for them for a trial of use. Then the DEA should permit that. And because they said no 1 month ago, we've been delayed. And so yesterday, we directed our attorneys to file for a petition to review this decision in the court. And so I'm hoping that the judges who look at that will take into consideration the great potential, the suffering of my patients, and the law and what their rights are to secure. And I'm happy to answer any questions. Thank you so much.
Well, and let's hold for questions until we hear from Erinn Baldeschwiler, who is one of Dr. Aggarwal's patients. And Erinn, I see you are on mute. So there you go. Thanks so much for joining us today.
Sorry, and I forgot to, let me introduce Erinn as well. I apologize. Please welcome Erinn Baldeschwiler. She is a patient of mine who is an amazing, has taken a great personal risks to speak on emotional risk to speak in this way about her health and her wishes. And I wish to just thank her tremendously for doing this on behalf of herself and, of course, potentially other patients in the future who could benefit. So please welcome Erinn.
Hello, my name is Erinn Baldeschwiler, as you've been introduced. I am 49-year-old mother of 2. I have 2 teenagers, and apologize, I haven't even started really talking. I'm going to start crying. So a year ago, I was diagnosed with, at the age of 48, which to me is young. I have a whole another half of a life I'd love to live. I was diagnosed with stage 4 metastatic triple negative breast cancer. It's not good. It was really bad. I got a really dire diagnosis. I was statistically given 2 years to live with modern treatment, and yeah, it's a huge cause of it breaks my heart, to be this young. And my son's birthday was yesterday, and anyways, I just wonder how many more I'll be able to enjoy with him and my kids. And so anyways, clearly it can cause a lot of sadness and anxiety and depression. And whatever remaining time I have left, I want to have the highest quality of life. And if I can relieve any of the sadness and the depression, it helps, to alleviate anxiety and depression, mental, emotional stresses that come along with the terminal illness. I was having a conversation with a girlfriend the other day, and she was talking about, my daughter getting married here. And the first things that pop in my mind are, will I be around for that wedding? These are the things that, come across my mind when talking with people is, will I see that? Will I be around? And it's really painful to think that I may not see my children grow into adulthood. It's painful to think that one day I might not be able to physically be there for them as they kind of walk through their journey in their life, and especially at times of, struggle and pain. And so it's just really hard. And, I'm very honored to be working with Catherine and Dr. Sunil, and I'm open to having access to therapy, any therapy that would help relieve, these anxieties. And as they mentioned, I don't have time. I'm a year into a 2-year diagnosis, and so I would love to have this opportunity, not only for myself, but also to keep this door open for others that are in pain and suffering, and mentally, and, with depression and whatnot. And there you go. I'm going to try to keep my talk pretty brief, because I don't want to blubber on camera too much. So I'm going to send it back to Catherine, I guess, and open it for questions.
Thanks so much, Erinn, and for participating. So we are able now to take questions from any of you that are eager to hear from any of us, whether the doctor, the patient, or the lawyer. And if you would put your question in the chat box. I know there is some kind of an opportunity to raise a hand, but I think you can also just type in the chat box. I have a question for Erinn that the journalist would like to know what your reaction was when you heard that the DEA had denied therapeutic use of psilocybin.
I was upset. I was angry. My understanding is I have a legal right under these laws, and I personally get very angry when other external forces try to block my own choices and decisions and options. And so it was very disappointing, made me angry. That said, I feel like I'm in very good hands with yourself, Catherine, and Dr. Sunil, and hopefully moving this forward and keeping this door open as we move forward for myself as well as all patients and medical professionals. So.
Yes, so much. You put a point on the reality that this is a question about your autonomy, your ability to make autonomous decisions about your medical care and your well-being. So very much appreciate that. Another question for you, Erinn, first with the appreciation that you have shared your story. Oh, I see. It's an appreciation to Erinn and a question for Catherine or Dr. Aggarwal. Can you update us on the status of the state level request? Yeah, so thanks for that question. As some of you who have been following this, and we started working together on this last summer, and because no one had previously attempted to access this eligible investigational drug under right to try, we were feeling our way forward. And our first thought was that, as of course, we would seek the medication, the investigational drug from USONA. Many of you know that USONA has been manufacturing psilocybin for the clinical trials that are going on. USONA was not willing, despite requests from Dr. Aggarwal with informed consents, to make that drug available. So we started thinking about whether the Ames Institute could manufacture its own supply of psilocybin by growing the psilocybe mushroom. And our first inquiry was to the Washington State Department of Health Pharmacy Commission with an application for registration to grow the psilocybe mushroom to produce psilocybin for therapeutic use. That application, we have asked that agency to put on hold, because we found another manufacturer who already has registration to manufacture and distribute psilocybin. That manufacturer was willing to supply the Ames Institute upon a showing of DEA permission. So we then approached the DEA for that permission, and we got the denial of therapeutic use, which is reflected in the DEA letter of February 12. So that's the status. Questions coming fast and furious. Let me scroll up. Yes, a question which is the crystal ball question. How long do you expect to take this to resolve? And do you expect the current administration to be more agreeable to psilocybin use than the previous one? We do expect to file a motion to expedite this case, because we have patients like Erinn who have the dynamic reality of progressive illness and no time to wait for the slow process to unfold. So we will seek a expedited hearing. Even with expedition, it will probably be a few months before we are in front of the Ninth Circuit on oral argument. but we'll certainly do our best to move it along. Also, will not rule out the possibility that the DEA will come to its senses and negotiate a resolution and do what our neighbor to the north has done, which is to permit this kind of access. And so we're going to stay very open to the possibility of a negotiated resolution without needing to go through the whole process at the Ninth Circuit. In terms of the current administration, well, you know, one thing I took some heart from with the new Attorney General nominee comments about respecting state law. He was commenting, Merrick Garland was commenting with cannabis in mind, that there would not be the devotion of federal resources to federal enforcement of the Controlled Substances Act, where states had made access legal. That restraint was reflected in the Obama administration and the Cole Memorandum, where that kind of a cooperative federalism approach was embraced. And so I think we've seen a signal from the incoming Attorney General that a return to cooperative federalism will be embraced in this administration. That said, that could not only be useful for what we're trying to achieve in this case, but also, as many reporting in the field know, Oregon adopted the first state legalization of psilocybin in the country in the November election, the Oregon Psilocybin Services Act. Cooperative federalism, of course, is very important to the functioning of the Oregon Psilocybin Services Act. So I think that comment from the incoming AG was really positive with regard to psilocybin access under that state law. Moving on, Leah from Psychiatric Times. This question I'm going to relay to Dr. Sunil. Curious as to the impact that you think this drug would have on the field of mental health as a whole. Big question. And in terms of collaborative care teams.
Yeah, thank you for the question, Leah. I think we know from it was first presented at the American Psychiatric Association a few years ago, some of the early data from the long-term, the therapeutic benefit in advanced depression cases. That was a clinical trial that was done, I believe. The Hopkins data was presented at the APA. One of my colleagues, Derek, he was one of the lead authors on that paper. And Derek May, Dr. May's data showed that they actually had to create a new scale to show the antidepressant results, because the scale that they were using was so, like, they didn't know, no other treatments had really ever fallen in like the amount of response rate was so high compared to what treatments were previously studied, traditional antidepressant therapies. So that kind of gave you an indication that we're potentially dealing with a a whole new approach to depression, and now there's data certainly in PTSD, with psychedelic therapy, and addictions. So these three, depression, anxiety, PTSD, addictions form, I mean, much of our mental health crisis in this country and around the world. And so to have a therapy that is showing such data in its clinical trials, not to mention a very long-standing historical, traditional, cultural use in many cultures, where this has also been borne out. This is this can portend great things, I think, for the future of mental health care, especially on patients who have failed therapies, traditional standard therapies, which is a high rate, unfortunately, in these conditions. So I think that would have a large impact, and I think it could really help help many people. I think in order for us to do that, there'll be a need for a significant amount of training for practitioners in mental health, to understand these therapies from the inside out, to know who are the right patients, who is safe for it. There's already work going on with the use of ketamine as a psychedelic therapy, and there's many clinics using ketamine-assisted psychotherapy as a treatment modality. And I think that will give you an example of what psilocybin-assisted therapy could look like and what impact that would have. And as far as collaborative care goes, it's, I practice integrative medicine. We are inherently collaborative, and I think it's important to have a collaborative approach when you have this kind of therapy available. So that means work with counselors, with therapists, chaplains, social workers, certainly medical doctors and nurses. And I think that's sort of the model we have also in hospice care. And when you're dealing with life-threatening illness, but certainly in mental health care with integrative models. So I think it would fit right into that. And that whole team could be part of a patient's healing. And of course, in the psilocybin therapy services model, I'm imagining a new facility where patients might go to get psilocybin therapy, but that does not mean that they would not have ongoing relationships with their mental health care team. And hopefully we'll see in the future referrals to the Oregon therapy places by mental health professionals as they learn who are the right patients for this and who could benefit. So that's what I think can happen in the future.
Thanks, Sunil. There's a question about where what's the backdrop of right to try. So for those of you who are legal beat reporters, you probably remember the case of Abigail Alliance. It was a landmark case that was about the question of whether a young woman in her 20s who was dying of cancer would be able to access an investigative drug. And she was denied access, and the case was about whether there was a federal constitutional right to access experimental medicine. And the holding out of the DC Circuit, the first holding was that, yes, there was that federal constitutional right. In an en banc rehearing, the ruling was no, there was no federal constitutional right to access experimental drugs. And cert was denied by the Supreme Court of the United States. So that was the last word on the Abigail Alliance case. That case became the catalyst really for the right to try movement, which really swept the country. I mean, to see 41 states and the federal legislature adopt a statute in such a short span of time as the past 6 years is really remarkable. And if you look at how these laws were adopted, just taking Washington State, for example, every single legislator on both sides of the aisle voted in favor. It was a unanimous approval. That's extremely rare in lawmaking. So there's a very strong support across the country for allowing access for seriously ill patients to access investigational drugs that have passed phase 1 clinical trials. And so that's why we're very eager to apply right to try to this particular investigational drug, which has shown such remarkable efficacy. So thanks for that question. What else? How has the DEA explained its refusal? Well, we don't have much of an explanation at all. And as mentioned on the Emerge Law Group website, you can open the DEA letter, that letter dated February 12, in which it rejects therapeutic use. It did make a suggestion in that very short letter that perhaps the clinician would want to apply to be a researcher. But again, we had made very clear that the intention here was not research, but therapeutic use. And those are, of course, are very different. And the research route is much more time consuming The idea of right to try, of course, is to respect the reality that the patients may not have much time. So to try to force a clinician seeking therapeutic use into a research avenue defeats and would vitiate the entire purpose of right to try. So we are really standing up to see the letter and the intent of right to try respected. And it is incumbent on the federal agency here, the Drug Enforcement Administration, to respect the law of the land. And one other case for the legal beat reporters that you may remember, and particularly I see the OPB reporter will no doubt remember the case of Oregon versus Ashcroft-Gonzalez, where there was an attempt by the United States Attorney General, first John Ashcroft, and then later succeeded by Alberto Gonzalez, to use the Federal Controlled Substances Act to nullify the Oregon Death with Dignity Act, where the voters of Oregon had approved that Death with Dignity Act. It was a duly enacted law. It was the law of the state of Oregon, and yet the Department of Justice, the Attorney General, attempted to use the Controlled Substances Act to say any physician who prescribed medication consistent with the Death with Dignity Act would be in violation of the Controlled Substances Act. The state of Oregon and a group of patients who I represented went into court the next day to seek injunctive relief and got it. And the case went all through the federal courts, including the Ninth Circuit, and then to the Supreme Court of the United States, which said that it is not permissible for a federal agency or the Department of Justice to nullify a state's determination of what constitutes a legitimate medical practice. That reasoning, you can see, has application here, where the state of Washington has approved access to investigational drugs, and the DEA is trying to nullify that. So I do think, for those of you who follow the legal beat, this case will have some really interesting precedent that we will be relying upon that will be familiar to many of you. And it's very possible that we will see the state of Washington taking a close look at this case and possibly taking a role in ensuring that a duly enacted statute is respected by a federal agency. Okay, let me take a quick look if we've left any other questions out. I think we've answered all of the questions. I'm going to pause in case anyone has a further question that they'd like to raise. And otherwise, we can thank you for your time and your attention. Oh, I see this one question about, I had mentioned the Oregon Psilocybin Services Act, which is the first state law to permit therapeutic use of psilocybin as a matter of state law. And the interesting question is whether terminally ill patients or seriously ill patients in Oregon could possibly access psilocybin services, psilocybin therapy, before the Oregon Psilocybin Services Act takes effect. Because those of you who've been following that enactment know it has a 2-year development period on the front end, which is only just now getting underway. So under that enactment, there would be no legal access to psilocybin in Oregon before 2023. So the answer to the question is yes. I think if we are successful in seeking access to psilocybin under right to try, Oregon patients who would fit eligibility under the Oregon right to try should be able to access therapeutic use before the Oregon Psilocybin Services Act takes effect. So I hope that's a clear enough answer of that question.
Catherine, I have a question I'd like to raise to answer, if that's okay.
Yeah.
This is regarding the medical practice. When we're in new territories, experimental therapies like this, investigational therapies, you need to know that there's a qualified group of experts within the field of medicine who also are, support this kind of therapy. And I think it's important for the media to know, and that the American Academy of Hospice and Palliative Medicine, which I'm a member of, I've been in some leadership roles there as well. This is the largest group of hospice and palliative medicine clinicians in the world. They have actually created a forum in their body called the Safe Use of Psychedelic Assisted Therapies group, which is now meeting regularly, and assigned staff support and a group of clinicians. It's a very popular group in the academy. I was one of the inaugural members of that group, and I can tell you there's great interest and support for Right to Try in that community of physicians and clinicians, nurse practitioners, who are really know that all of our patients don't have the luxury of time to wait for the drug development pathways, and that these are treatments that should be available now for these patients. So I just wanted to state that. I've also, our colleagues to the north, Canada, and in Canada, some of the leaders in palliative medicine actually came from Canada. And they have already, I've worked alongside a little bit with TheraPsil, who is the organization that's helped to secure psilocybin assisted therapy for terminally ill patients by petitioning to their local health authorities. And I've been following those cases, and the patients have done very well, who've been able to have access to this treatment. They've given media interviews and were very positively affected in terms of their quality of life, and mental health and mental well-being, spiritual well-being. And I think it's, that's just a hundred or so miles from where I live. So we're in the same professional circles. So this is not something that's so far from the field of medical practice in my specialty. And I just wanted to share that with the group.
Yeah, and
finally,
I follow up to Sunil to suggest the possibility that the American Academy of Hospice and Palliative Medicine, some of its former presidents, both Ira Byock, who is well known to anyone who covers end-of-life care, and Tim Quill, same thing, another former past president. They are both very supportive of adding this palliative care tool to the toolbox. And they come to the issue from very different perspectives on other end-of-life choices. As you may know, Tim Quill, from the Supreme Court case, Quill versus New York, is very supportive of patients being empowered to choose aid in dying. Ira Byock has spent his career opposing that choice, and yet they both support access to psilocybin therapy, because in the debates around whether dying patients should be empowered with the choice for aid in dying, everyone agrees that no patient should make that choice due to inadequate palliative care. And the reason why psilocybin as a therapeutic tool is so important and exciting to palliative care community is that it fills that gap. We've done so much progress to advance pain and symptom management of physical symptoms, but not as much progress has been made around the existential distress, the non-physical suffering. So I wouldn't be surprised, and I'm going to be hopeful that the American Academy of Hospice and Palliative Medicine will participate in this case by filing an amicus brief. I think we'll see a lot of amicus participation, and very possibly by that organization that has such an authoritative voice on the needs of seriously ill and dying patients. I do see a question for Dr. Aggarwal. Will you explain the difference? Could you touch just briefly on the difference between psilocybin and some of the other psychedelics as the research is progressing, if you care to do that?
Thank you. This is each psychedelic is has a different, duration of action and oftentimes mechanism of action. Some patients may be better at taking one versus the other based on their tolerance levels, what their stamina is, how long of a therapeutic session they can have. LSD has still not gone through a lot of clinical trials in this country, although in Switzerland we've seen LSD for cancer patients, and there's been some really positive results there. There was also historical use of LSD in the first wave of psychedelic therapy in cancer patients in, I believe it was in Illinois in the 60s, if I'm not mistaken. And there were some really impressive results in advanced cancer patients for dealing with the pain. Even the physical symptoms of pain got better in advanced cancer patients with LSD, not to mention emotional pain and psychic pain. We call that total pain in palliative care. And there's actually been some recent research on low doses of LSD for treatment of experimentally induced pain. So these substances, LSD may have some unique features. MDMA is being studied and it's now in phase 3 trials for PTSD. That's being done by MAPS, the Multidisciplinary Association for Psychedelic Studies. And, I think there was an end-of-life study that got published recently with MDMA. It didn't have as positive favorables, but we think that it had to do with the mix of patients that was involved in the study that was done by Dr. Wolfson. But many people are interested in MDMA also for a treatment for family members, for caregivers of patients who are terminally ill, due to looking at the caregiver distress, burnout, and trauma associated with caregiving and end-of-life hospice care. So I think all of these substances will all have different places and roles depending on the patient that you're looking at. So it's kind of a whole field of medicine now, and I think it's important that we have these options available so that we can study them and actually, use them in our patient population. We're continuing to study as well, but in palliative care and hospice, we're very used to using things off-label, and even though it hasn't been studied for that condition in that quite detail, because as Catherine is saying, if it's safe, which is what a phase 1 study shows, safety, then it's time to be able to use that in patients who don't have much time.
Thanks for that. And then I'm just going to close with this question. Will there be access to this taped presentation? I have, I believe, succeeded in recording it. And so I would say the answer to that is yes, and that would be posted somewhere at the Bauman Group website. I don't know, Brad, if you want to say how people might be able to access the recording.
Yes, we'll be able to post it both on our website, and Catherine, we could probably get it on your site as well.
Okay.
And then we may deploy it as well via YouTube so that people will be able to view this going forward.
Great. Hey, thanks so much. So we're coming up on the hour, and I think we've answered all the questions. I want to thank everyone, and feel free, of course, to follow up. And I'll turn it back to you, Brad, if you want to close.
Yes, I've gotten several requests from the media for some follow-up materials, which I will get out right away. If you have any questions or you need to get in touch with Catherine or the doctor or Erinn, just let me know. My email is brad@goteamtbg.com. And we look forward to helping you all out. And thank you very much for your participation on such short notice.
All right. Thanks, everyone.
Bye-bye.